welcome everyone. It's exciting to have such a full house with us today. Thank you for joining us this evening. The time is 5:31. We are going to call to order this is actually not a regularly scheduled meeting. It is a specially scheduled planning and zoning meeting in the city of Middleton. The time is 5:31. The day is Monday, March 25th. My name is Idaho Summers. I'm the Planning and Zoning Chairman. Would you all please rise for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Will the deputy clerk please do a roll call of the commissioners?
Chairman Summers.
Here.
Commissioner Cross.
Here.
Commissioner Tremble.
Here.
Commissioner Watkins.
Here.
Commissioner Sparrow.
Here.
Commissioner Waltmake.
Present.
Commissioner Gregory.
Here. And do we have a quorum?
We do.
Perfect. Okay, so we will move right on to our action items. We've got our action items in our consent agenda, which are our items of routine administrative business. We need to consider approving the minutes for the February 12th, 2024 regular meeting. We also need to consider approving minutes for the February 15th, 2024 special meeting. We need to consider approving the FCO for the Zamco variance application. And we need to consider approving the FCR for the Riverwalk Crossing Development Agreement modification application. Anybody find anything in those items that needed to be amended, corrected, questions, anything? Nope. Okay, I'll take a motion to approve action item number 1, the consent agenda. Do we need to do each of them individually? Nope, the whole thing? Okay.
Motion to approve consent agenda items A, B, C, and D.
Okay, I have a motion to approve. Do I have a second?
Second. Oh.
Rock, paper, scissors?
No, go ahead.
No. Okay, so second by Sparrow. So I have a motion by Watkins, second by Sparrow. All those in favor say aye.
Aye.
Aye. Anybody opposed? Okay. Moving on, we do have a public hearing next. We will be considering recommending approval to City Council of Ordinance 693, an ordinance enacted by the Middleton City Council amending Title V, Chapter 4, Section 050404, Middleton City Code pertaining to requirements for the submission of a preliminary plat, providing for an effective date, providing for severability, and repealing all ordinances, resolutions, orders, and parts thereof in conflict herewith. Call to meeting by public, call to order open by public hearing, and
Actually, I should probably state,
open at
Council
5:34.
Member David Murray is going to go ahead and present, but I will fill in a couple of just legal gaps at the end. So I'll bounce back in, but he's going to get us started.
Okay, Councilman Murray.
Yeah, what do you do?
Oh, do I need to give my name and address and all that?
Yes.
Money over here on this side. Dave Murray, 1573 Glencoe, Middleton, 83644. So, we will start at the beginning because Julie Andrews taught us that's a very good place to start. Constitution of the State of Idaho, Article 9. Says the stability of a Republican form of government depending mainly upon the intelligence of the people, it shall be the duty of the legislature of Idaho to establish and maintain a general, uniform, and thorough system of public, free, common schools. This has always been a thorn in the side of the legislature. it led to a series of Supreme Court cases starting in the 80s and going through the early 2000s, culminating in ISEEO 5, from which I pulled a few shots here. The Supreme Court found that the bonding system for schools in the state was not constitutional. It did not uphold Article 9. Amber, go ahead to the next one. And they quote multiple other states who have found alternatives and ways to ease that and help out. And going on 20 years later, the legislature still has not fixed that. And I'd like to point out that a constitutional right is not a constitutional right if it can in fact be revoked by the lack of a popular majority vote. This is an article on the lack of impact fees in the state of Idaho. This article is from 2019, and they were talking about how CUNA needed impact fees then. If the legislature had been forward thinking enough 5 years ago, we wouldn't be in the state that we're in, because we would have had impact fees in place, and we would have been able to bond against that and build a new school. Amber, next. The current state of our schools. This is from 2022, so this is going on 2 years ago. The article quotes Mill Creek as being at, I think, 123%. That's not the case anymore. It's now at 138%. Heights is at 120% or more. Purple Sage is still under capacity, but that is only because it is the home of our special needs programs in this district, and so it is kept artificially low to cater to the needs of those students. Another article talking about projected growth in the future due to studies from our school district and how many students they're expecting to be bringing in. Amber? About a year and a half ago, reading through code, I came upon this section, which says subdivision ordinance 676513. Each governing board shall provide by ordinance adopted, amended, or repealed in accordance with the notice and hearing procedures provided under section 676509 Idaho Code for standards and for the processing of applications for subdivision permits under sections 1301 through 501329 Idaho Code. Each such ordinance may provide for mitigation of the effects of subdivision development on the ability of political subdivisions of the state, including school districts, to deliver services without compromising quality of service delivery to current residents or imposing substantial additional costs upon current residents to accommodate the proposed subdivision. Amber, next. So the point that I'm trying to make here is that the current situation is not in fact the fault of developers or developments. It's not the fault of citizens. It's not the fault of cities and counties. We have had no mechanism under state law to mitigate against the harm of kids pouring into our schools. We have only one option for building a new school, which is the supermajority bond. So last time we ran one, it passed at 55%, but because we require a supermajority, it failed. Our ordinance would alter our code and add in these following portions. School capacity. A signed statement from any school district in which a subdivision is located verifying that the proposed subdivision upon completion shall not cause or contribute to the total service obligation of any public school that will be serving the subdivision to exceed 110% capacity of such school except as follows. Small developments. The foregoing capacity verification shall not be required for subdivisions where the total number of lots is fewer than 5. The developer, Amber, shall not be permitted to avoid the obligations of this subsection by artificially partitioning a large development into smaller developments. Infill developments. The foregoing capacity verification shall not be required for subdivisions where the total number of lots is fewer than 10, and such subdivision is an infill subdivision, which shall mean any proposed subdivision that is immediately adjacent on at least 3 sides to the municipal boundaries of the city of Middleton, and which is also entirely within the municipal boundary of the city of Middleton. As used in this subsection, each school's capacity shall be determined based upon the total of the actual capacity of such primary school facility added to the actual capacity of any permanent structures used to house students at said school facility. Actual capacity, this is important, actual capacity of common areas, restrooms, lunchrooms, libraries, and similar spaces shall be taken into account when determining the actual capacity of additional permanent structures used to house students at school facility. I'm going to pause. That portion is really crucial because in the past the solution has always been add a portable, add a portable, add a portable. Schools have infrastructure just like towns. Schools have bathrooms, lunchrooms, gyms, all these common areas that students need. And when that school is designed and built, it is engineered to house a certain number of students. So you can add as many portables as you want, but if you're not adding infrastructure, you are harming those children's education, as well as possibly their health and welfare while attending that school. I'll continue where I left off. As used in this subsection, total service obligation shall be calculated by adding the total number of built and buildable lots, including lots in all phases of any subdivision that has obtained preliminary plat approval, within the area served by such school, together with the total number of buildable lots located within the proposed subdivision, and multiplying said number by the student per EDU number. EDU is equivalent dwelling unit, and that refers to the studies which the school district conducts regularly, estimating how many students per home are added. So the last study was 0.64 or 5, I think, students per home. As used in this subsection, student per EDU number means that number calculated annually by the school districts and acknowledged by the city council, which is the average number of students expected from each residential dwelling unit built or existing within said school district. There shall be a student per EDU number calculated for each category of students, elementary, middle, and high school students. School districts shall use a reasonable and substantiated method for determining the student per EDU number. So essentially, the school district, let me back up. When a developer wants to submit an application to the city, they will be required to get a letter from the school district, not saying yes or no to the subdivision, simply stating, yes, we have capacity. If there is not capacity at whatever school that they are building within the boundary of, be it elementary, middle, or high school, no letter will be provided. Without that letter, the development application, the packet, will be incomplete. And I think that's all. Is there any questions for me? Oh, and Roberta has some additions because I'm lacking.
Let me just go through a couple of things to put on the record. Roberta Stewart, planner. So there were no comments from the public received, nothing attached to the agenda. No governmental comments also. And anytime we try to change the subdivision code, we have to prove per code that it's not in, that it's still in harmony with the comprehensive plan. And so, on the record, I would state that my finding in reviews that it's not in conflict with the comprehensive plan because it doesn't conflict with any goals or objectives that are set forth in the plan. So the code, the ordinance does meet that criteria. And I think I'm done.
Douglas, would you like to throw your hat in the ring at all?
The Councilman, I don't have anything right now that I would want to, I feel obliged to add, but I'm happy to answer questions that come up, so.
If I can add one more thing, I forgot to elaborate on this. This really, in my mind, this is my opinion, but my opinion is that this is not opinion because it is a constitutional right in this state. If the state or federal government attempted to tamper with someone's First Amendment or Second Amendment rights, and it was within this city's ability to protect against that, we would do so without failure. Just because it's the schools doesn't make it any different. Article 9 stipulates that kids have a right to an education in this state. So I just wanted to elaborate on that. I'm sorry.
Thank you, Councilman Murray. I'll start with some questions that I have, and just a little historical context for you. This school problem has been in Idaho for a really long time. I was born and raised here in what is now West Ada School District, and they couldn't get bonds to build new schools, and there was like 6,000 kids at Meridian High School at one point, and they had sophomores, juniors, and seniors. All seniors started at like 6 a.m. and sophomores got out at like 6 p.m. because they had to stagger them throughout the day. So this is nothing new, obviously, so I appreciate your efforts in trying to hopefully solve some schooling issues that we have going on in the state of Idaho. Am I correct that there was not a comment from the school district on this, or is this school,
You're correct.
so they didn't have any comment on?
And it was sent to them.
Okay, so they haven't been involved in any of this, the findings or the,
They did assist in the drafting. We made sure that we communicated with the schools to make sure that we would not do anything that would harm them or affect them in some way that was unintended. We spoke with Valley View and with Middleton schools back in fall of 22, I think it was. And then again early this year where we did some minor alterations in the wording in it. And I believe it was presented at the school board meeting in March, yes. So the school board has seen it and has had the opportunity to discuss it.
okay. And then remind us again what, I know you stated the percentage of, that this most recent bond didn't pass, essentially. What is the supermajority in the state of Idaho?
I believe it is 66.7% must vote in favor in order to pass it.
Okay. And when we're talking about funding schools the way it currently sits, which is what this ordinance is trying to, this isn't really changing the way schools are funded so much as just slowing
No.
growth to,
It will hopefully make a statement, but its primary goal is to protect our schools against further harm.
okay. So it's not really impacting the way that schools are funded. It's not giving another avenue for school funding or anything like that, because that's done on the state
No,
level.
I covered all of that to try to enunciate, to make the point that the fault, like I said, the fault is not on citizens. It's not on cities or counties or even on developers. The fault rests with the legislature and the way that our laws are currently written and the fact that the political willpower is lacking every single year. So I showed you snippets and anybody here can look it up. ISEEO was the name of the cases as they went through the Supreme Court, 1 through 5. And the Supreme Court found in favor of the, was it Idaho Students for Educational Equal Opportunity or something like that. And they ordered the legislature to fix their funding mechanisms, and I'll go a little bit further in here. So within Article 9, it says a thorough, right? And the Supreme Court defined thorough as safe and conducive to learning. And the Supreme Court essentially told the legislature, you must address these two things. And the legislature did. They fixed the safe because at that time there were schools which were quite literally falling apart and were deemed unsafe for students to be in. The second portion, the conducive to learning, to this day, the legislature has not defined it or instituted any mechanism by which a school can say, one of that article that I had up there regarding Mill Creek, it spoke about how at that point in time, classrooms were happening in hallways, in teachers' lounges. So if the legislature had defined what conducive to learning is, Mill Creek could have applied, Middleton School District could have applied and said, we do not have an environment conducive to learning because we have classes happening in hallways. But if you don't have a definition, and you don't have a mechanism, then schools just have to deal with it. And I'm sorry, I tend to go on rampages. But
No, that's kind of what I was hoping for. And so then I got just a couple more questions, and I'll let the rest of the commission ask. Are there any other county, city, school districts in the state of Idaho that have maybe attempted to do something similar to what you are presenting for Middleton code change?
to my knowledge, this will be unique to the city of Middleton. I do not know of any other county or city, and I reached out to many at this point in time, who has this. They have similar for wastewater or intersections, things like that, but not for schools. A secondary or even a third goal of mine is to make the city of Middleton and hopefully the rest of the state following us consider schools to be infrastructure. As they are a right, they are necessary, and so if you're going to build, then you need to ensure that you have capacity, the same as you do at intersections or roads or wastewater or electrical or anything else.
Okay, and so then where did you guys get the backbone for this, or is it just something that kind of was created?
Well,
Is there,
we've been sitting on it for about a year and a half. We finished, I think, the original draft that we did, we finished in earlier midwinter of 23. And from that point on, myself and Council President Kaiser went to Cannon County, and we went to the city of Star, because there are 3 governmental bodies that approve land use in our school district. So the reasoning behind that is if the city of Middleton were to adopt this alone, we may very well pass it, but then developers will simply turn around and go to the county, or go to Star, who's now building in Cannon County and in our school district. And the homes still go in, the harm is still done, but now we don't have any property tax revenue to offset it, or offset that. We have the kids at our schools, we have people on our roads. So we were trying to partner with the county and with Star, and we met with mostly silence over here and a brick wall over here. So we've been sitting on it for a while, and I've been talking to absolutely everyone that I meet, and I think I've spoken to you about it, I've spoken to you about it, I've spoken to you and you. I haven't spoken to you too much, but I would if you gave me the chance, and this is the first time I'm meeting you, but see me after, we'll talk more about it. Pretty much anybody I meet, I talk to about it. So maybe I nagged enough people into it to build the willpower, I don't know, but.
so we don't have a brick wall over here anymore, and we don't have silence over here, or?
There's still silence from the county.
Okay, so we don't have the cooperation yet.
We do not have
to
partners
support
yet.
this.
I think a lot of other cities and counties who I've reached out to are interested to see how things go for us. But I am optimistic about our future, and that other cities and counties will join us. It's always scary to be the first to do something, but that doesn't mean that it's wrong or that you should not do so.
Yeah, okay. And then one last question, you may or may not know this, but the answer to this, but Middleton School District, at least historically, has had an open enrollment policy where children can come from anywhere and be a student of our school district. Do they still have that policy? And how is that going to play into this? All of these potential children that we have in our schools that we obviously don't want to kick out or anything, but we may have more than. That may be part of why we're over capacity.
What you did was just give me an opportunity to take another swing at the legislature, and I thank you for that, because it's a hobby of mine. So, state law passed a year or 2 ago, made it, in the favor of school choice, made it so that any student anywhere in the state must be accepted at any school that they apply to, so long as there's capacity. That's all well and good. But given the current system of funding schools, let's say that tomorrow, magically, we pass a bond and we build a school. So now our schools are below capacity. You could have kids from Greenleaf, from CUNA, from Meridian, from Eagle, who will all go to a school in our school district, but they will not be paying on that bond. So state law stipulates that we must, as long as we have capacity, yes, and the school district, to the best of my knowledge, follows that law. But if it opens us up to be footing the bill for kids from outlying areas, which I strongly disagree with.
Yeah, it would be interesting to see some statistics on whether part of our overage is due to open enrollment laws. That'd be just something I'd be interested in. Okay, so those are all of my questions that I had. Anybody have questions for Councilman Murray?
I do.
Commissioner Gregory?
The common areas. Would that help eliminate some of the portables, or just the option to always just shove more portables at it?
Can you elaborate on your question?
Well, you said that actual capacity of the common areas.
Mm-hmm.
So would they still be allowed to put up portables? Or
No, so to my, I mean, the school can put up portables
Right.
if it wants to, but for the purposes of this ordinance, and my understanding is, and Douglas, if I'm interpreting it wrong, please feel free to holler at me. What that is saying is essentially, in a much longer, elaborate way, is that school was engineered for a certain number of students
Right.
with the common areas, the various common areas, to support that number of students. And so when you're figuring what your actual capacities of school are, you can put 20 portables in there, but because of the common areas being taken into account, your capacity is still here rather than artificially raised.
Right.
Is that?
Yeah, that's correct. Essentially, the common areas are going to act as a cap on whatever the capacity would be. So if a school installed a portable because they wanted more space for some class that had a smaller size of some, I don't know what it would be, calisthenics or something, and they needed more space, that wouldn't result in, oh, now the school has more capacity, we got to fill that portable up. And it may be the case that there are schools with common areas that were over-designed and they have more capacity than classrooms, and so that school may be able to have some portables that are used as essentially permanent facilities. But whatever that blend of things is, at the end of the day, those common areas will act as a cap.
Okay, thank you.
Any other questions, Commission? Commissioner Sparrow?
Councilmember Murray, I know that when Mayor Hutchinson was discussing this at the city council meeting, she had tasked you and Mr. Christiansen with getting some outside opinions.
Mm-hmm.
Is that something that you can speak to in this meeting?
Yeah, no, so I don't want to quote anything directly because honestly I don't know if there's attorney-client privilege that covers that, but I can say that we got 2 outside opinions. And given that this is novel, that it's new and never been done, they came back pretty glowing. There were no major concerns. I guess I don't. Like I said, I don't know if attorney-client protects too much, but yes, they came back positively.
And then the other question, I know that just so the commission knows, me and Councilmember Murray have talked about this quite frequently. When we had a conversation with Superintendent Gee, Middleton students, based on this school choice, Middleton students have first priority, correct?
Well, anyone who lives within the boundaries of one of our schools automatically has a right to go to that school. They cannot be denied.
Right.
And to my understanding, I can't speak for Superintendent Gee, but to my understanding, if we have, say, Mill Creek right now at about 138, and a kid from Star or Meridian applies to go there, I don't believe the school would be accepting them. But yes, within the boundaries of our school district, it's not just priority. They have a right to it. You cannot deny them.
That was my understanding as well. That was the only question I had.
Okay, anybody else? Commissioner Watkins?
Just a couple of clarifications as we went through. Regarding the developments that aren't subject to this, I just want to make sure we're clear on the numbers. So any new development that's not an infill, max 5, correct?
Yes.
And then infill 10.
Well, it says less than 10, so I believe
Less
that
than
would be 9.
Okay.
Is that right, Douglas?
So,
It's 9, yeah.
9.
Yeah, 9.
Okay, no, perfect. And then one other clarifying, just so as we talk about capacity, just so we're clear, we're all clear. I said it's based on, the capacity is based on infrastructure. The hard set, not portables, not that, but what the school can provide infrastructure, right, Douglas?
Yeah, so Commissioner's capacity is determined based upon the total actual capacity of the primary school facility and any permanent structures used to house students at the school facility. So if there was a portable that qualified as permanent, it would count towards the capacity, and then eventually you bump up against the common areas being over capacity. So
Yeah, that's not how it work. That's all I had. So I just making sure I was keeping up.
Okay, Commissioners, any other questions? Commissioner Trumbull?
Mr. Murray, the EDU calculation, 0.65 or whatever it is, say we have some capacity in the high school, but not in the grade schools.
Mm-hmm.
Eventually, they're going to, how is that separated in the letter of recommendation?
So it would cover all schools. So if I were going to build, let's see, if I were going to build anywhere on the east side of Middleton Road, then my applicable schools would be Mill Creek Middle School and High School. If the middle school and high school have capacity, but Mill Creek does not, there's still no letter. Because you can't know, unless you're going to get the home buyers lined up and take a census of, you know, all their kids and the ages and all that. You can't know exactly how many you're going to get in each one. But the studies that the school district does estimates per home, and then within that, there's estimates of roughly this number should be elementary, roughly, and it's percentages. And most of those end up going to the elementary schools, which are the ones that are overburdened at this time. And that makes sense because you have K through 5, middle school, you only have 6, 7, 8, and high school. So most of your students are by nature going to go to elementary schools.
That's all I got.
I did have a question after Watkins talked about less than 10 and 5. Help me understand where those numbers come from, because if we don't have capacity, we don't have capacity. Why even put a number on it?
I don't even remember how that came up in our original planning.
I can speak to it. So, those numbers are policy decisions, right? They could be 10 and 20, or they could be 2 and 3. And so, in general, though, one of the consequences of something like this is that it does have an impact on the value of land and what you can do with it. And so that, as well as in general, cities prefer, as a policy decision, to have infill development. If they could push a button, if it's a binary choice, infill is preferable because it keeps the utilities closed, keeps things from sprawling. And so during the discussions, those were added as component exceptions to try to address some of the concerns like that. But at the end of the day, they are not required. The legal opinions that were provided about the ordinance were about the ordinance as in its current state. But anyway, those are just policy decisions that the P&Z can have an opinion about, like, not like, etc.
So is it my understanding that you put those numbers in there to protect individual property owners' property rights?
Well, I think that's fair to say. So any law that you write which limits someone's rights, you never want to shut them down completely. What you're trying to do is find a balance between protecting kids' rights to an education and private property owners' rights to exercise whatever they want to do on their land. Now, if you let private property rights take precedence, the children lose theirs. If you shut down all private property rights to protect the children, so you have to find a middle ground. And I think what we did there with those numbers is a fairly good, minimize the harm to the schools while not eliminating all economic viability from the land. Does that sound fair, Douglas?
Mm-hmm. That was the understanding I was looking for.
Commission, any other questions?
I have a question. I don't know how to phrase it, so I'm going to just try. I'm an educator. I feel your pain, I know. I mean, I look at my classes. I don't teach here, but I have taught in many different school districts. So my question is, let's say that I move my family to Middleton. We move into the Middleton School District. And I know that, I think Middleton has a CTE program. They have other programs that bring other kids into the district. Okay, so my child is allowed to go to school even though Mill Creek, for example, is over capacity, yes or no?
If you live
Because we moved into the district.
Yes, if you live within the Middleton School District,
Yeah,
the kids
okay.
have a right to attend.
Yeah, that I understood that. I wrote that down. I just wanted to be sure. I just, to me, it just seems more logical to get rid of the ones that don't live here. To get rid of the ones that don't live here. But I know that's probably not real fair, because maybe you have a kid who is started when he was a freshman in high school, and now he's a junior and getting ready to graduate next year. But losing some of those kids and making room for our own kids, but that might just be too easy. I don't know. I have no problem though with this.
I can't speak to that, but
No.
I mean, if I were at the helm, I think I would look at that. I think because I grew up in a family of educators, 2 generations, both sides, and I think schools also try not to disrupt a kid's environment too much. So if you accepted a kid in 2018, before there was a real big problem here, and they started the kindergarten in Mill Creek, and now they've been working their way through the schools, and they've established friends, and they're doing sports here, all that. You don't all of a sudden want to just say, get out and go get yourself a new community. And I can't say that's what is happening, but you know, I know that does happen. It's a hard ship to sail. If nobody has another question, I would like to add one more thing, which I forgot. I get a little scatterbrained. Is there any more questions about? So I have heard concerns about the school district as a separate taxing entity. That's not our lane. We need to stay in our lane. And I would argue completely the opposite. The school district can give input when we're looking at land use. You all have seen that on this board. But they are not an approval or denial body. Only the city and the county are. So the responsibility is incumbent upon us and upon the county to assess the impact of developments on every single taxing entity that home will be in. And that includes schools. And we need to ensure that we protect them as much as we can, because those other taxing entities can't protect themselves. They don't have to have a say in yes or no. Only we do. I think that's all.
Thank you. So no more question for Councilmember Murray? Okay. Do we have some people signed up? Okay. All right, before I open the public comment section, I do want to read over my testimony guidelines. If you have not already done so, please silence your electronic devices, and please keep your talking to a minimum so we can get a clear recording of tonight's meeting. If you need to talk while you're seated in the audience, please be respectful and step outside so as not to disturb the public testimony. If you are offering public testimony on this agenda item, make sure that you're on my list. If you're not, then you need to get on it. And there will also be a designated time at the end of this meeting that's reserved for general public comments that are not related to this agenda. So if you are wanting something generic to talk to the Planning and Zoning Commission about, save your comments for that for later. And then we'd also like to make sure that everybody has the time to give their testimony during this allotted time, because we do have a lot of people here. We have a lot of people on my list. So if somebody before you has stated the same testimony as you plan to give, you may simply record for the record that you agree with the previously shared testimony. You may also give any additional new testimony as applicable. When your name is called, you will be asked to come up to this podium, clearly state your name and address for the record. You will be given 3 minutes on the clock. Please keep your testimony to the 3 minutes. If you're not quite done, we will allow a courtesy additional 1 minute, but you need to wrap it up in that 1 minute. And especially if you have additional items that you think are pertinent to our ability to make a decision tonight on whether or not we're going to recommend for approval or denial to the City Council. And with that being said, we will open our public testimony portion of this public hearing at 6:09 p.m.
Commissioner Summers, if I just have 4 or 5 questions that I'd like to pose, either Mr. Murray, about it, not real testimony about the impact of the ordinance, but I have about 4 or 5 different questions, sub-questions about it.
So you could get up and you could ask them, and then we'll bring him up at the end, and he'll
Okay.
answer them for you.
Okay,
Yeah.
I want to put my name on that.
Okay.
Check the box for testimony.
Actually, you'll need to do it on another sheet because this one's full. So is there
Is his
another
name
sheet?
already on there?
Is your name?
I'm
who's your-
already on there.
Oh,
We just
then
need to check the box for testimony.
I'm gonna call everybody because nobody fills it out right. I mean, not nobody. That was a really broad statement. I'm really sorry about that. My husband warns me that I can't talk broad like that. Some people do not fill this out right. So just to give everybody the benefit of the doubt, I'm gonna call on everyone.
Okay.
Okay.
Thank you.
All right. David Louise.
Commissioner Summers, I don't need to speak. I probably filled it out on one.
No, you didn't. You did fill it out just in favor.
I'm just in favor.
Okay.
I wanted that to be on the record.
Perfect. So David Louise is in favor. So if you did not mark that you wanted to testify, Do you feel like that, do you want me to tell you who Mark testified? And then if you think you really wanted to testify, maybe we go there, because I only have 4 people that Mark testified. Okay, I have Mike Grave, Mark that you want to testify, Janet Gibson, Don Reynolds, and Mike McDougal. Did anybody else in here want to testify that's on my list? Okay.
Howard.
What's your name?
Crawford. It's
Crawford.
just below my grade.
Okay. And who else?
Ken Burgess.
Okay. Anybody else?
Howard Rothman, I think second.
Howard,
from the
okay,
bottom.
got you. Anybody else? Okay, so I'm just gonna read down that you're in favor or you're opposed, okay? And then we'll get to the ones that Mark testified. Okay, so Tom and Kate Rice are in favor. Mikkel Galloway, am I doing this okay? That's okay for me to do this? Okay. Mikkel Galloway is in favor. Mike Grafe is in favor and would like to testify.
Yeah.
You can come up. It's your turn.
I really didn't want to wait. Because I have to admit, I'm Mike Grafe, 1889 Ridgeway.
Okay, 3 minutes on the clock.
Okay. This has done more to confuse me than it has to really settle anything in my mind. But are the subdivisions in Canyon County that are in Middleton area of impact and have subsequently been annexed by Star sending their kids to Middleton schools? And I think that was answered, yes, they are. But the overcapacity, okay, let's do it this way. What happens if that subdivision that's in our area and all that in our school district got annexed in? They're not paying any of the taxes and stuff for the city of Middleton, which don't go to the schools, I understand that. But their kids, if that subdivision pushes the school over capacity, can they stop those kids from coming to the school? Or who, I don't really quite know how to understand that, because they're Middleton, but through some screwed up deal with legislation and whatever else, they got annexed into the city of Star. And anything west of Canada used to be, and is in the area of impact, and it's in Canyon County, but you got a real screwy deal there with kids that are in Star who are home or main part of Star is in Ada County. It just, I don't know how you come up with something. The bill is good. I'm all for this code for Middleton, but I don't know how that comes to play. Are you gonna, if the subdivision A is here and it's in Star, subdivision B is here and it's actually all Middleton, and this subdivision's gonna push it over capacity, and this one wouldn't. But if this one was done first and it's in Star, the kids in Middleton, right next door, wouldn't be able to attend the school in Middleton. I just don't understand this. If it's at the state level or city level or whatever else, something is really major screwed up here.
Yeah, so we'll have Councilman Murray talk about that when he comes back up.
Well, if it's
So
clear to you guys, it can help me out a lot, because it sure isn't clear to me.
yeah, we'll see what Councilman Murray has to say about that. Hopefully it's clear to him.
Thank you.
Thank you, Mike. Okay, Patty Crawford. Name and address for the record, and then 3 minutes on the clock.
Okay, thank you. Patty Crawford, 8359 Spring Creek Way, Middleton. I've got a couple comments here. First of all, I'm in support of what Mr. Murray has said. We have schools that have already reached capacity in this district. We have schools, and my figures are we're from August of 23, but we were at 90% capacity. Our elementary schools were 118 and 144% capacity. When we build a new development, we add .596 kid that's what it was. It may have changed, but we add that. Right now, we have approved 2,800 homes. For me, if I've done my figures accurately, that means we have 1,600, we've got 1,668 more kids coming to this school. If they build from Canada this way, they're in the Middleton School District. We don't tell them they can't come. They are in the district. We talked to Dr. Gee, Superintendent of Schools, and we a year ago, only had 308 kids who were out of school, and they've been here for a while, and that number has decreased because as they graduated, he gave us a commitment to our city. He would not bring another kid into our school that was not in our school district. We're asking you not to put more kids in our district than we can accommodate. If we're looking at the new star development, that's 1,500 homes. That's 2,500 homes. That's about 1,500 kids. That's 3 elementary schools on top of the 3 elementary schools that you've already got. I say elementary schools because they're the cheapest to build. I don't know if they're high school, I don't know if they're junior high, but I know that a high school costs a heck of a lot more to build than an elementary. We are now faced with an additional pressure, which Mr. Murray addressed. I think it's House Bill 1025 or something to that effect. And what that does is that said any kid in the state of Idaho can go to school in this district if we have space. After 2 years, they're grandfathered in. So if you say, sir, after 2 years, I'd like to have them go because now I'm full, doesn't work that way. They now are in this district. I asked Dr. Gee if we could go ahead and say, I know I have this many kids in elementary, they're going to be moving to junior high, they're going to be moving to high school. That's not what this law is allowing us to deal with.
1 minute to wrap up.
I will. We've added 13 portables. Those portables cost us $250,000, and another $20,000 to $40,000 per portable to get them up and running. I'm saying we don't have impact fees that we're allowed to use. 1025 is affecting us. We've got houses on the books. We are beyond capacity. Think about that, please. Thank you.
Thank you, Janet. I'm sorry, Patty. Thank you, Patty. Ken Burgess.
Madam Chairman, Commissioners, how are you? Hi, my name is Ken Burgess. My office address is 801 West Bannock Street in Boise. I am in the government affairs business, and one of my clients is the Snake River Valley Home Builders Association. So these are the guys, they're the single family residential new home construction industry folks. And I'm here to express at least some concern and some potential unintended consequences that I want you to be aware of. But I'm going to reverse my testimony because Councilman Murray was talking about, and he's absolutely right, the responsibility of the Idaho legislature to do more to fund school facilities. And I wanted to just give you a brief update on kind of where that is beginning to evolve, because I think it is beginning to evolve. Last year there was a bill passed that trickled out about $158 million to school districts for the purposes of using that money to buy down their school bonds that they currently have on the books. That did probably provide some legitimate property tax relief around the state. This year, just last Thursday, House Bill 521 was passed. It is another very large step, I think, I hope, into the states taking some responsibility in school facilities. It added to that mechanism another $175 million that will be used for paying down bonds and any plant facility levies that exist. But then there was an additional $1 billion that is included in that over a 10-year period that is being distributed out to school districts on a student population basis. So just that bill that passed yesterday, and I'm sure the governor will sign it tomorrow or the next day with great fanfare, no doubt. I looked up, I have a chart here. The Middleton School District will get $1.9 million from that first pay down thing, and then they will get roughly $17 million from the second portion, which is that. And they can take it as a lump sum if they want at the beginning, or they can take that over a 10-year period. So I just thought that might be, because you're absolutely right. It is a problem that the state needs to take on, and I do lobbying for a living. I do believe they're finally kind of taking those first few baby steps to taking some responsibility there. I do not see them ever getting to the point, however, where the local folks don't have some skin in the game, meaning that they're not going to pay 100% for a facility, right? But they're still going to require some sort of bonding authority or a bond to be passed by the community. And so I just want to make you guys aware of that. Ms. Crawford addressed the open enrollment students. There's a document on the Middleton School District website where it is true they did stop taking any open enrollment students in 2021. So my concerns. Statewide, we've got a couple problems. One is we've got housing prices that are out of the roof. My guys are attempting to do what we can. It's a supply problem, right? My guys are attempting to do what they can to try to meet that supply, drive those prices down. Middleton School District and others thus are now having, because of the growth, some overcrowding problems. There's no doubt about that. And what Middleton, what we believe is the community of Middleton, in order to really solve their problem today, needs to pass a bond in order for them to make meet those facility demands. If this ordinance passes, here's my concern, is that it will effectively become a de facto moratorium on building within the city of Middleton. Now, the question is, what is the impact of that if that were to happen? So first of all, long-term impacts of the property tax income for the city could be significant. It will, as Mr. Murray noticed, probably force development into the county. And those county developments are going to build out and surround you. And those students are still going to have a school to go to, first of all. And second of all, it's going to put an additional strain on the city facilities, parks, roads, and that kind of thing. So I just, and then the last thing is we are concerned that if you pass this, the community will be put into some sort of false sense that the school problem has been solved. And as a result, they would be even less inclined to potentially try to pass a bond into the future. And so I just wanted to get that on the record and make you aware that those are the concerns that we're having and some things that ought to be thought about that maybe are not at the moment. Thank you, ma'am.
Thank you. Okay, Diana Hoffman, you are in favor. Did you want to testify?
I do. I've looked all of them up.
Okay, well, you didn't mark it, but I'm going to mark you now.
I did not mark that I wanted to speak, but
Name and address for the record, and you'll get 3 minutes.
I was making notes. Diana Hoffman, 27990 Grace H. I'm actually not within the city of Middleton, but I am within the school district and in those areas that are impacted. So I do pay the property taxes. And like Mr. Murray said, this would be the first bill of its kind or ordinance to go into effect. Then Mr. Developer said that the state is working on stuff, making baby steps. Well, baby steps does not fix the extreme issues that we are having in Middleton. So that I don't really care to hear about that at this time. But just to be the first to go get this going, I think that would help put pressure on the county commissioners, who obviously need to do something that's going to put pressure on the city of Star, and every other city around here is probably going to rally and continue to adopt these very similar ordinances.
Okay, thank you. Janet Gibson.
Janet Gibson, 945 Harvest Way. I'm in complete accord with what you just said. That was wonderful. I don't think I need to remind you guys, every time we have a public hearing on a new subdivision, at least one resident comes up and says, but you don't understand our schools. They're over capacity. You know, anyone who who doesn't think that that's the case, go back and look at the minutes, right? I can't remember one where somebody didn't bring that up. So obviously this is an issue that we've had to deal with for quite some time. This ordinance finally takes a step. And I think one of the things that has happened in Idaho is it's the same old, the same old, the same old. Nobody has tried to step forward with something new and innovative to address these population issues that are just exploding throughout the southern part of the state in particular. For Middleton to be that city that steps up and does something that is so influential is a feather in our cap. Because we're finally taking back ownership of our city and the education of our kids and all the infrastructure. He's right, infrastructure includes schools. And if we don't address that, that's exactly the same thing as looking at 44 and saying, it's okay, it's a 2-lane highway. We know we have, 5 million people driving up and down every day. It doesn't really matter. Well, this is even more important. This is the future of Middleton.
Right.
And this ordinance takes that step. Is it perfect right now? I think it's pretty darn good. Maybe it needs to be tweaked, but it needs the opportunity to be put forth so that we can actually benefit from this sort of thought. So I hope you guys take that into account. The residents here think this is really important. You know that, and it is really important. So I thank Councilman Murray, and I thank you guys for considering it.
Thank you, Janet. And Schumacher. Schumacher.
I just scribbled in there.
Yours just says that you're in favor.
Yes.
Okay, perfect. And then Howard Rankin, you are in favor and would like to testify.
Yes.
Okay, name and address for the record, and 3 minutes on the clock.
Howard Rankin, 551 7th Street, Middleton. And it's wrong, and it's probably my spelling and writing is not that accurate.
I see it's Rankin now, sorry.
Just a couple questions about it. Not necessarily any order, but school occupancy, how are those numbers calculated? And is the school superintendent the one and only authority on issuing those figures? And if so, will those figures be able to be contested? The reason I ask that question is that I've sat in a meeting with a developer and their representatives, and they brought up the high school, which the developer said that school is not at capacity. Well, it was bantered back and forth, the issue of it's for special programs or accommodated there. So would that just be this school is designed for this number of students and this is how many are attending and that is set? Would those numbers be able to be contested in any way? And if our schools are currently at or over capacity, does that mean that no new plats will even be reviewed or approved? And if so, when would this ordinance take effect? And would it apply retroactively to those plats already proposed and or approved? Also, if this ordinance does pass, which I hope it will based on Ms. Gibson's comments and those before her, will the county and STAR just continue to do business as usual, or is there anything that can be done to encourage them to get on the same page with us? And lastly, what can we do to get our state legislators to fix the education funding situation? That's all.
All right, he looks like he's a fast rider. Okay, thank you. Deidre Templeton. Is Deidre here? She did not mark anything, so Deidre's neutral, I guess. Don Reynolds.
Did I fill it out correctly?
Yeah. In favor and testify.
Well, I've offered a lot of suggestions in that regard. Don Reynolds, 452 East Walcott Lake Court, Middleton. This is a topic in my house that gets lots of attention and lots of discussion. We don't always see things eye to eye, coming from two different perspectives. I've worked as a background for many developers, both directly and indirectly over the past few years. We moved to Middleton 16 years ago or so for the sake of the schools. Coming from Driggs, Idaho, we had many people who were, surprisingly, a lot of people who moved from here who suggested Middleton as the place to be for school districts. We got involved in the parent advisory committees and have been trying to get involved in their community, and we appreciate that, so I understand the need there. I appreciate Mr. Burgess's perspective. I think all views need to be heard on this. I think there are some potential impacts that could be raised that need to be considered and at least looked at and viewed. But I do think that the state gave our school district $1.2 million in funding, and then the school turned around and tried to bond for another $1.2 million because of the way schools are funded and the way their bank accounts and budgets are set. All that money can't be used and utilized cross budgets and cross fields. So I think people need to understand that, and I think our school district could do a better job at helping explain. I think an important part of this whole process is really partnering with the county and adjacent cities, because not only is STAR impacting Middleton and Middleton school districts, so is Caldwell, and I think that's an important role. I've stood at this pulpit many times talking about Middleton being unique and standing out, and how that's caused problems for developers and builders, and I think that some of those issues still need to be addressed and resolved. However, I think in this case, Middleton being unique and standing up and taking a stand in this regard is right where we need to be. I think it's for the right reasons, in the right way, and from what I can read and can see, it is legal and the appropriate way to move forward. So I think this is the right way to go. My question would be, what about 55 and older communities? My understanding, as has been said, is that the number of outside kids attending our school districts, it really isn't that many, and most of those kids that do attend our school districts are coming because their parents teach here, and I think that's something to be considered and aware of. The other piece of this is, while the city is looking to address this as an ordinance, it's important that we get involved with our school district as well to help them make decisions and support them in the role that they play in helping pass bonds and funding for our schools. And I appreciate Councilman Murray and his work in this regard, and his work for future endeavors to try and change the way schools are funded in the state of Idaho, because I think that's really where this problem lies.
Thank you. Mike McDougall.
Hi there, Mike McDougall, 13037 Greenwell Lane, Caldwell, Idaho. So, a couple things. There's been a lot of discussions I've been part of in different realms. I disagree with the housing being a supply problem, and I think there's facts to bear that out. Houses are sitting on the market a lot longer than they used to. I don't have those numbers, I've heard them, but I would dispute that idea. I'll start with January 30th. There was a sewer workshop meeting right here that said we're at capacity, and there was even concerns about the water. This is just one of Middleton's problems. It's not the only problem. And I want to say thanks to Murray and Kaiser for saying, hey, this is also a problem and there's no way to address it. So in my opinion, this is the first step. We can't solve all the problems, and we're working on some of them, but this is one that no one has a tool by which to work with or work at. So these guys have gone to bat and tried to find a tool, because we need to work on freaking everything, and it's just one of the items. So I'm of the opinion that if it's within the bounds and the work has been done to see that we can do this, then we take steps in that direction. I think other cities will follow, because we're not the only ones dealing with this. But we've got water, we've got sewer, we've got overcrowded roads. These are all symptoms of poor management and poor planning or rapid growth, but there's more than just this. And this is a tool, and I think we need to implement it. Talked to Mr. Gee at length. Most of those points have been made. Every time I write notes, I never what I'm going to say, so if I got notes, I'll probably forget. The point is, I agree with this. I think it's a move we need to make, and I applaud you gentlemen for pushing it out there, and I would ask you guys to consider it and recommend its approval.
Thank you, Mike. Okay, we have nobody else signed up. can put your name on this. And then, so up to the podium. There we go. Name, address, just any address they can reach you at if they need to. Okay. Name and address for the record. You have 3 minutes.
Okay. My name is Cindy Powell. I live at 2351 Old Middleton Road here in Middleton. I have lived in Middleton virtually all of my life. I taught in the Meridian School District, aka West Ada, and I am standing up here as a past retired teacher, special education, and have taught in a portable. And on all the things that David put up there as far as the law conducive kept coming out to learning. And having taught a year in portable, it is not conducive to learning. They do not have restrooms in them, there's no water. So having been at Meridian Middle at the time when it burned, we were out in the parking lot where driver's ed was being taught as well, and kids had to go into the school for restroom use, any of the other classes that they were going to, music, PE, they had to do that. As far as learning, it is not a good place for children to learn inside the portable. And every portable that's in any school district will be basically a portable. It will be able to move. It's not permanent. They move them all over the district in where they're needed. I came up as the person being a past teacher, but I am also a member of the Middleton School District School Board. And I don't try to advertise that very much, but we are over capacity. In 2 of our elementaries, we will be even more so in the middle school when 5th graders move up to 6th grade. Basically, the law that is the open enrollment law, if I'm not mistaken, that has been changed and we have to let them in. We stopped a while back in 2021, I think it was. I could be a little bit off, but we have to keep a child. If they come to us in 1 year and stay the 2nd year, like Patty said, we end up, they have to stay, whether they're a 2nd grader or an 8th grader. They can stay the rest of their school time. I want you to know that Mr. Gee and the school board have been in talks with the city in terms of David and all that he's doing with this ordinance. So he's not here. I came as a past teacher, but to let you know, we do know about this. We brought it up in the last meeting and all the members do realize what's happening. And as far as I know, I'm definitely for it. I know it may put things on what Mr. Burgess had said, as far as the community in a false sense. I think they're going to know. If they have kids in school, they're going to know that there's a need there. Also, I need to say, I have been on past bond committees, and he also mentioned, that's what we need to do is pass a bond. And I'm not supposed to promote that, but that's the citizen.
Thank you, Cindy.
Thank you very much.
David.
I'm sorry to interrupt. Mr. D is about 10 minutes away. If there's any way to postpone it.
Is he on his way here?
On the way. 7 minutes.
I suppose I have 10 minutes of hot air. I can fill the gap.
We're gonna take a 5-minute recess. We'll be back at 6:40.